Civil procedure. Civil procedure. Proper court. Venue. Courts must have personal jurisdiction, PJ, over the parties. Subject matter jurisdiction, SMJ, be held in a proper venue, and defendants must be served with proper notice. Venue is proper where any defendant lives if all live in the same state, where a substantial portion of the claim occurred, tort occurred, contract entered into, etc., where a substantial portion of the property is located, or, if none of the above apply, where any defendant is subject to the court's personal jurisdiction, PJ. Personal jurisdiction, PJ. Jurisdiction over the parties, specifically the defendant, considered waived if not challenged initially. Traditional basis. Party is domiciled in the state, present in the state when served notice, or by consent. Corporations. All states where incorporated, principal place of business, or having systematic and continuous contacts in the state. Modernly, a proper long-arm statute allows the court to exercise personal jurisdiction over an out-of-state defendant, where the tort happened, contract entered into, advertising, etc. Minimum contacts, such that the exercise of personal jurisdiction will not offend traditional notions of fair play and substantial justice. Purposeful availment. Defendant purposely availed themselves of the benefits and protections of the state and could reasonably expect to be held in a court there. Fairness factors. Convenience to the parties, location of the evidence, judicial and state interests. Subject matter jurisdiction, SMJ. SMJ is non-waiverable. Jurisdiction over the law and facts. State courts are courts of general jurisdiction. They can hear almost any type of case. Federal courts are limited jurisdiction. There are two types. You see here how federal courts are limited. Federal question. Cause of action must arise under federal law and in the initial complaint. Remember, states can hear any case other than non-exclusive federal claims. Diversity. Different states. Complete diversity. Amount in controversy greater than $75,000 at the time of filing may be aggregated or combined. Complete diversity. No plaintiff and no defendant may be residents of the same state at the time when the action commenced. It is perfectly fine to move, creating diversity, and then file the case. And that's an MBE question. Citizenship determined by natural person, domicile with intent of remaining. Corporation, state of incorporation and nerve center or headquarters. Keep in mind all states that the corporation is incorporated in. Unincorporated association, citizenship of all members and partners. Alienage jurisdiction, none, unless a U.S. citizen is on one side of the case. Supplemental jurisdiction, SJ. The federal court may hear additional state court claims when they arise under the same transaction or occurrence, common nucleus of operative fact, even if the court would not have heard the claim for lack of SMJ, subject matter jurisdiction. Service of process. Notification to the defendant of the pending action and a copy of the complaint, allowing the defendant the opportunity to be heard. Service may be by anyone at least 18 years old who is not a party to the action. Personal service is delivered directly to the defendant. Substitute service can be left at the defendant's usual abode and served upon anyone of suitable age and discretion who resides there. Served to the defendant's authorized agent or as permitted by state law. California, substituted service is only allowed if personal service cannot be accomplished with reasonable diligence. Service may be left at the defendant's usual abode with a competent member of the household who is at least 18 years old, and that person must be informed of the contents. Constructive service, by registered mail, but only if the defendant agrees to waive service. California, by publication if nothing else works, plaintiff must provide affidavit after reasonable diligence. Foreign country service, service as the court directs or in accordance with the laws of the foreign jurisdiction. Removal, defendant may remove an action to the federal court having SMJ. All defendants agree. No defendant is a resident of the forum state, and removal generally sought within 30 days of the complaint. There are circumstances which allow more than 30 days, but multiple defendants need to be served for that to apply. Exception: defendant may not remove a case if sued in their home state when the only basis for removal is diversity. Remand: if federal court has no SMJ, case must be remanded. Motion to remand must be within 30 days of the notice of removal. Choice of law and diversity actions. Erie Doctrine. A federal court must apply state substantive law to resolve claims under state law. Case will use federal procedural law. Pleadings. Federal courts require notice pleading, a short and plain statement of the claim showing that the pleader is entitled to relief, and the demand for the relief sought. California uses fact pleading, like fraud below. In alleging fraud or mistake, a party must state with particularity the circumstances constituting fraud or mistake. Malice, intent, and knowledge may be alleged generally. Discovery. Parties may discover non-privileged matter which is relevant and proportional to their claim or defense. Request for physical or mental examination requires a court order upon a showing of good cause, must be related to the claim, and requested in good faith. Scope of discovery. Need not be admissible if reasonably calculated to lead to the discovery of admissible evidence. California must be relevant to the subject matter involved in the action. Privileged material is not discoverable. Attorney work product created in anticipation of litigation. Interrogatories. Limited to 25 without leave of court or opposing party stipulation. Cannot be served prior to the initial conference 26F, also known as the meet and confer. Res judicata, claim preclusion, precludes relitigation where there is a valid final judgment on the merits. Federal, when the final judgment is rendered. The same plaintiff and the same defendant in the prior and subsequent case. Same claim is asserted in the prior and subsequent case. Federal, all legal theories arising from the same facts, same T&O, transaction or occurrence are the same claim. Same T&O means same facts. Collateral estoppel, issue preclusion, precludes relitigation where there is a valid final judgment on the merits. Federal, when the final judgment is rendered, same issue was actually litigated and the issue was necessarily determined essential to the judgment. Can only be used against a party in the prior suit in the interest of fairness. Can only be used by, traditionally, a party asserting collateral estoppel had to be a party in the prior case. Discussion of the below points is rarely, if ever, needed. Defensive use, shield, to avoid liability in a subsequent suit will be allowed where the party against whom collateral estoppel is being asserted had fair opportunity to be heard on the critical issue in the prior case. Offensive use, sword, to establish an issue in a subsequent suit is disfavored and will be allowed only when it is fair and equitable.